Hello and welcome back. This is the Kelso Report's Supreme Court Review for the October term 2011, and I'm your host, Clark Kelso. We cover the October term in 4 separate installments, covering constitutional law, commercial and civil law, government law, and criminal law. In this second installment, we take a look at the major cases decided by the court in the fields of commercial and civil law. We had a pretty broad range of commercial and civil cases this year, encompassing securities law, patent, copyright, communications, civil procedure, arbitration, general civil law, bankruptcy, labor law, taxation, and workers' compensation. A very wide spread for the Supreme Court. Although some of these cases are so narrow and technical that they defy easy generalization, I think we continue to see in the court's commercial and civil decisions a pro-business trend, and we see in some of these decisions Justice Sotomayor joining the more conservative justices on the court. Let's begin with securities law. Last term, the court 2010 term, the court had 3 important securities law cases and several important class action decisions. This year we had no really important class action cases and only 1 securities law case, and that decision involves a narrow question about when the 2-year limitations period for a Section 16B claim starts to run. In Credit Suisse Securities versus Simmons, the Supreme Court looked at this issue. Now, under Section 16B of the Exchange Act, a corporation or security holder of the corporation may bring suit against the officers, directors, and certain beneficial owners who realize any profits from the purchase and sale or sale and purchase of the corporation's securities within any 6-month period. According to the statute, suits must be brought within, quote, 2 years after the date such profit was realized, close quote. Well, the plaintiff in this case filed an action under Section 16B to challenge transactions that occurred many years after the 2-year period had apparently passed. The Ninth Circuit permitted the actions to go forward, holding that the running of the 2-year period was tolled until an insider actually files a disclosure statement required by Section 16A of the Act. The Supreme Court in Credit Suisse Securities unanimously reversed, holding that this interpretation was at odds with the text of the Act. Since the theory of liability under Section 16B is a novel one, the practical result of the Ninth Circuit's rule would be that many insiders who plausibly did not think they had any filing requirement at all would remain potentially liable for decades. The Supreme Court held that the Ninth Circuit should have analyzed the case under ordinary principles of equitable tolling. And those principles include a requirement that a plaintiff have pursued his or her rights diligently and that some extraordinary circumstances stood in his or her way. The court remanded to the Ninth Circuit so it could apply the equitable tolling doctrine to the case. It'll be very interesting to see if the Ninth Circuit at this point finds some way to hold that, nevertheless, the running of the limitations period was tolled. Lower courts sometimes react negatively to being reversed. Well, the court was quite a bit more active in the fields of intellectual property and regulated industries. The results are somewhat mixed, although it was, I think, heartening to see the court issue a few rulings this year that suggest good limitations upon what appears to have been a headlong rush by the Patent and Trademark Office to grant patents to pretty much anything that moved. Let's begin with a couple of cases involving patent rights in the healthcare industry. First, we begin with the question of generic drugs and generic drug approvals. When the Food and Drug Administration evaluates an application to market a generic drug, it considers whether the proposed drug would infringe a patent held by the manufacturer of the brand name version. To make that assessment, the FDA requires brand manufacturers to submit descriptions of the scope of their patents, known as use codes. Now, the FDA does not attempt to determine if that information is accurate. Instead, the FDA just assumes it is accurate and then decides whether to approve a generic drug on the basis of that information. As a result, the breadth of the use coding may make the difference between approval and denial of a generic company's application. And it certainly gives the patent holder some ability to frustrate generic drug uses by inaccurately stating the use codes. In Caraco Pharmaceutical Labs versus Novo Nordisk, the Supreme Court considered whether Congress has authorized a generic company to challenge a use code's accuracy by bringing a counterclaim against the brand manufacturer in a patent infringement suit. The relevant statute provides that a generic company, quote, may assert a counterclaim seeking an order requiring the brand manufacturer to correct or delete the patent information it submitted. In a victory for the generic drug manufacturers, and I think for the public's pocketbook, the court held unanimously that a generic manufacturer may employ this provision to force correction of a use code that inaccurately describes the brand's patent as covering a particular method of using the drug in question. The patent holder should not be permitted to extend the scope of its patent by inaccurately stating the use codes. And the Supreme Court's holding provides a mechanism for a generic drug manufacturer to keep the patent owner honest. Our second patent case also involves drugs. In this case, the question is just how far an inventor can go to patent nature. The Supreme Court has repeatedly held that laws of nature, natural phenomena, and abstract ideas are not patentable subject matter. This limitation upon what is patentable under the patent laws ensures that the basic tools of scientific inquiry, natural phenomena and laws of nature, are not monopolized in a way that would stifle innovation and discovery. But since all patentable ideas are at some level built on the foundations of natural phenomena and laws of nature, drawing the line between non-patentable laws of nature and patentable inventions can be difficult. The court's jurisprudence distinguishes between a law of nature itself, which is not patentable, and, quote, an application of a law of nature or mathematical formula to a known structure or process, close quote, which may well be patentable. In Mayo Collaborative Services versus Prometheus Labs, the court had to decide on which side of the line a particular drug protocol fell. The drugs at issue were thiopurine drugs used in the treatment of autoimmune diseases. A problem with these drugs is that the proper dose is influenced by each individual person's metabolic rate. Based on some prior art and additional research by the applicant, the patent set forth a precise protocol for how much thiopurine to administer based upon the level of certain metabolites in a patient's blood, essentially instructions for use. The Supreme Court unanimously held that the patent was nothing more than a rule of nature and was therefore unpatentable. In particular, the court concluded that the analytic steps in the protocol, apart from the natural laws themselves, involved well-understood, routine, conventional activity previously engaged in by researchers in the field. In other words, apart from the natural laws, which the applicant certainly can be credited with discovering, there was nothing at all patentable in the protocol. Finally, involving patents, we have a case involving judicial review of PTO decisions. Under the Patent Act of 1952, if a Patent and Trademark Office examiner denies a patent application, the applicant may file an administrative appeal with the PTO's Board of Patent Appeals and Interferences. If the board also denies the application, the applicant may appeal directly to the Court of Appeals for the Federal Circuit under Section 141, or alternatively, may file a civil action against the PTO director under Section 145. The District Court in Capos v. Hyatt held in a Section 145 proceeding that the applicant could not introduce new evidence, and the deferential substantial evidence standard from the Administrative Procedure Act applied. The Federal Circuit, in an en banc, reversed, holding that new evidence could indeed be introduced in a Section 145 proceeding, and that when such new evidence is introduced, the trial court must make de novo findings of fact, as appropriate, to take into account the new evidence. The Supreme Court granted review and unanimously affirmed the Federal Circuit. Nothing in Section 145 suggested that there were any limitations upon the evidence which could be introduced. Instead, the section created an independent remedy by civil action against the director. Section 145 did not contain any of the limiting language found in statutes creating limited judicial review of agency actions. And for these reasons, the court held that the applicant could introduce new evidence in Section 145 proceeding, and the district court had the obligation to enter new fact findings as necessary. So you have two very different ways of appealing a PTO decision in a patent case. Now we turn to copyright and the Byrne conviction. In a victory for globalists and a defeat for American orchestra conductors, musicians, and producers, among others, the Supreme Court held in Golan v. Holder that the statute implementing certain provisions in the Byrne Convention for the Protection of Literary and Artistic Works, which had the effect of taking a large number of works out of the public domain and subjecting them to a term of copyright protection, that was within Congress's powers under the Copyright and Patent Clause and was not prohibited by the First Amendment. The Byrne Convention has been around since the late 1800s, but the United States joined only recently in 1989. In order to perfect U.S. implementation of Byrne, and as part of our response to the Uruguay round of multilateral trade negotiations, Congress in 1994 gave works enjoying copyright protection abroad the same full term of protection available to U.S. works. In particular, Section 514 of the Uruguay round extended U.S. copyright protection to pre-existing works of Byrne member countries that lacked protection in the United States for any of three reasons. First, the United States did not protect works from the country of origin at the time of publication. Second, the United States did not protect sound recordings fixed before 1972. Or third, the author had failed to comply with U.S. statutory formalities that Congress no longer requires as prerequisites to copyright protection. The petitioners in Golan v. Holder included, as I mentioned, orchestra conductors, musicians, and publishers who formerly enjoyed free access to works which Section 514 removed from the public domain. Their argument was that the Copyright and Patent Clause provided no authority to Congress for removing a work from the public domain, and that the First Amendment similarly prohibits such a move. The Supreme Court disagreed, finding nothing in either clause that purported to limit Congress's power to extend intellectual property protections to works that had already entered the public domain. While there may be limits on how Congress can regulate the transfer of such works, neither the Copyright and Patent Clause nor the First Amendment makes the public domain, in any and all cases, a territory that works may never exit. Well, that's it for the intellectual property decisions. Our final case in this section involves the Federal Communications Commission's attempt to police the airwaves for expletives and nudity. The Federal Communications Commission had found that Fox and ABC violated federal decency laws in the context of fleeting expletives on two shows and momentary nudity on another show. At the time of the shows, the FCC policy pretty clearly indicated that fleeting expletives and brief nudity would not violate the FCC's interpretation of the applicable statute. However, FCC policy subsequently changed in another case, and then the FCC applied the new policy to the Fox and ABC shows. Well, in FCC versus Fox television stations, the Supreme Court held that the FCC's actions were unconstitutional, because neither Fox nor ABC had been given fair notice that such fleeting broadcasts were forbidden. Accordingly, the court held that the FCC standards as applied to those shows were unconstitutionally vague, and the court reversed the FCC's orders with respect to those shows. This is actually a very narrow holding, since the court does not reach any of the First Amendment issues directly presented by the FCC's new policy, which does make fleeting expletives and momentary nudity subject to sanction. The only holding here is that Fox and ABC did not have sufficient notice at the time their three shows were broadcast, which happened a decade ago. The court decided only one pure civil procedure case this term, and it involved the narrow question of what it means to be an interpreter. The issue before the Supreme Court in Taniguchi versus Can Pacific Saipan was whether compensation of interpreters as a component of an award of court costs includes the cost of translating documents, or whether it is limited to translation of live speech. Section 1920 of Title 28, as amended by the Court Interpreters Act, includes, quote, compensation of interpreters, close quote, among the costs that may be awarded to prevailing parties in federal court lawsuits. The Ninth Circuit held, in this case, that costs of interpreters, including the cost of translating from Japanese to English certain documents that were used in preparing the defense. On a 6-3 vote, the Supreme Court reversed, focusing its attention on the ordinary meaning of interpreter as someone who translates orally from one language to another. While the word could possibly be stretched to include document translation, that was not its ordinary or plain meaning, and that's what the court stuck to. Now again this year, the court issued a series of decisions about arbitration, and in most of the cases, the court essentially was fighting a rearguard action against lower state and federal courts that do not seem to have the same enthusiasm for arbitration as the Supreme Court does. Time and again, the Supreme Court is having to reverse lower court decisions that, in one way or another, tried to protect consumers and others from arbitration, so that their claims could be litigated in court. The problem with these lower court decisions is that the Supreme Court has interpreted the Federal Arbitration Act as expressing a broad policy in favor of arbitration. So let's take a look at the cases this year. First, the United States Supreme Court returned to the issue of the enforceability of arbitration clauses in consumer contracts with its decision last term in CompuCredit Corp. This term in CompuCredit Corp. Versus Greenwood. Now, as I have commented before, the court is much more favorably disposed to enforcement of arbitration clauses than are many of the lower federal courts, including the Ninth Circuit and even the California Supreme Court. Once again, the issue is whether the Federal Arbitration Act's requirement that courts enforce arbitration agreements really meant what it said. This time, the argument was that the Credit Repair Organizations Act somehow rendered arbitration agreements unenforceable. The problem was that the Credit Repair Organizations Act doesn't even so much as mention arbitration anywhere in its language, and there was no language establishing that proceedings had to be held exclusively in court. So the Supreme Court had absolutely no problem in holding that the Federal Arbitration Act applied in an 8-1 decision with only Justice Ginsburg dissenting. Next, in KPMG versus Kaki, the United States Supreme Court, in a per curiam opinion, vacated and remanded to the District Court of Appeal in Florida a case involving the issue of whether certain claims were arbitrable. The Court of Appeal had focused on 2 of 4 claims that were not arbitrable, and then apparently determined on the basis of that conclusion that none of the claims were arbitrable. Well, that approach is contrary to federal case law, which requires that if a dispute presents multiple claims, some arbitrable and some not, the former must be sent to arbitration, even if this leads to piecemeal litigation. On remand, the Florida Court of Appeal will examine the remaining 2 claims to determine whether either requires arbitration. Our next reminder came in Clarksburg Nursing Home and Rehabilitation Center versus Marchio, where the Supreme Court reversed this time the Supreme Court of Appeals of West Virginia. The West Virginia court held that as a matter of public policy under West Virginia law, an arbitration clause in a nursing home admission agreement adopted prior to an occurrence of negligence that results in a personal injury or wrongful death shall not be enforced to compel arbitration of a dispute concerning that negligence. Well, this type of broad bar to arbitration has repeatedly been held by the U.S. Supreme Court to be preempted, and that is what the court held again in its per curiam opinion in Clarksburg Nursing Home. A state may neutrally apply broad principles, such as unconscionability, to arbitration clauses, but it may not simply target arbitration by special rules, such as the one adopted by the West Virginia Supreme Court. We'll see if these three decisions this year send a strong enough signal to lower state and federal courts about arbitration. We turn next to a couple of cases involving particular civil actions. Both cases involve narrow questions of statutory interpretation, and in both the plain language of the statute prevailed. No real fireworks in these decisions. First, the Torture Victim Protection Act of 1991 authorizes a cause of action against an individual for acts of torture and extrajudicial killing committed under authority or color of law of any foreign nation. The plaintiffs, relatives of one Azam Rahim, sued the Palestinian Authority and the Palestinian Liberation Organization, alleging that the Authority and/or the PLO tortured and killed Azam while he was visiting the West Bank. Resolving a split of lower court authority, the Supreme Court held that the word individual in the statute was properly interpreted as meaning only natural persons, and that the Torture Victim Protection Act therefore does not impose liability against organizations. The court affirmed the district court's decision dismissing the action. Next, we have a case arising under the Real Estate Settlement Procedures Act, which provides that no person shall give and no person shall accept any portion, split, or percentage of any charge made or received for the rendering of a real estate settlement service other than for services actually performed. That's Section 2607 of Title 12. The plaintiffs filed suit alleging a violation of this statute because they allege the defendant charged them for fees for which no services were provided in return. The District Court in Fifth Circuit rejected the complaint, holding that the statute only applied to split fee situations. The Supreme Court unanimously agreed with the lower courts, finding the statutory language to be unambiguous in focusing only on situations where a charge for settlement services was divided between two or more persons. The statute simply does not address the claim that a single entity charged for a service that was not delivered. So the plaintiff's complaint under Section 2607 was properly dismissed. Well, we had one important bankruptcy case this year where the court made sure that creditors don't lose important rights through a cram down. In Radlack's Gateway Hotel versus Amalgamated Bank, the Supreme Court handled a rather technical but very important issue involving sales of a bankruptcy's estate's assets free and clear of a creditor's lien. The Chapter 11 bankruptcy plan provided for the sale at auction of certain collateral free and clear of a creditor's lien, but did not permit the creditor to credit bid at the sale, instead requiring the creditor to bid cash. Anticipating that the creditor would object to this, the debtor sought to confirm the plan under the cram-down provisions of Section 1129 of Title 11. Affirming the decision of the Seventh Circuit, the Supreme Court unanimously agreed that the proposed plan did not conform with the requirements for a cram-down. In particular, Section 363K of the Bankruptcy Code expressly protects the right of a creditor to engage in credit bidding when the creditor's interests in a cram-down are to be furthered by sale of collateral. The debtor sought to have the cram-down approved on the independent alternative ground that its plan was the indubitable equivalent of the creditor's underlying claim, an argument the Supreme Court easily rejected in light of Section 363K's express protection of credit bidding. Next, we turn to two labor law decisions. And in both cases this term, the court came out against labor. The court remains a relatively friendly business zone, or business-friendly zone. First, in Christopher v. SmithKline-Beacom, the Supreme Court had to interpret the scope of minimum wage and maximum hours requirements under the Federal Fair Labor Standards Act in the context of pharmaceutical sales reps whose primary job is to obtain non-binding commitments from physicians to prescribe their employer's prescription drugs in appropriate cases. In a close 5-4 judgment, the court held that these employees satisfied the definition of outside salesmen under the applicable Department of Labor regs, and were therefore not protected by minimum wage or maximum hour rules. The regulations were ambiguous in one crucial respect. They defined the term to mean any employee whose primary duty is making sales within the meaning of the statute, and who is customarily and regularly engaged away from the employer's place or places of business. A sale under the regulations includes any sale, exchange, contract to sell, consignment for sale, shipment for sale, or other disposition. The question for the court was whether a non-binding commitment from a physician to prescribe a particular company's drugs constituted a sale under this broad definition. Although this reg has been on the books for decades, there had never previously been an issue about pharmaceutical sales reps. The Obama administration's Department of Labor began enforcement actions in 2009. In a series of amicus briefs, the administration several times changed its interpretation of what constitutes a sale, until it ultimately took the position before the Supreme Court that a sale necessarily involved a transfer of title. Now, as we know, ordinarily agency interpretations of their own regs are entitled to deference. But rather remarkably, both the majority and the dissenting opinions agreed that the department's recent, novel, and changing, and litigation-focused definitions were not entitled to any deference, and the court was thus free to simply interpret the regs as written. The majority read the list of things that constituted a sale and held that the pharmaceutical situation fell within the other disposition catch-all. The dissent read the same language and held that a non-binding commitment simply fell short of a sale. This is a close call on the merits and a big victory for the drug industry. But I think the most important part of the opinion from a legal perspective is the court's broad rejection of agency deference in a context where the agency's interpretations are being driven by the demands of litigation and politics instead of apparently being driven by the demands of policy and law. We had a second labor law case, this one involving the First Amendment. The Supreme Court has previously protected the First Amendment rights of members of public sector unions to ensure that their dues are not used for political, ideological, or other purposes not germane to collective bargaining. In its 1986 decision in Teachers v. Hudson, the court identified certain procedural requirements that a union must meet in order to collect fees from non-members without violating their rights, including sending out what became known as a Hudson notice, estimating how much would be spent on such speech and securing consent. In this term's decision in Knox v. Service Employees, the court faced a situation where a union had imposed a special additional assessment to raise funds to meet unanticipated expenses associated with combating a statewide initiative. To protect the rights of members who don't want to contribute to the union's political speech, the court held that the union must provide a fresh Hudson notice and may not exact any funds from non-members without their affirmative consent. The decision closes what could have become a pretty large loophole in the Hudson process. The court had 2 revenue and taxation cases this year, and as is usually the case in tax cases, it all comes down to statutory construction. First, under Chapter 12 of the Bankruptcy Code, farmer debtors may treat certain claims owed to a governmental unit resulting from the post-petition disposition of farm assets as dischargeable unsecured liabilities. One such claim is for any tax incurred by the estate. Well, the question presented to the court in Hall v. United States was whether a federal income tax liability resulting from individual debtors' post-petition sale of a farm was incurred by the estate and thus dischargeable. In a close 5-4 decision, the majority held that the federal income tax liability resulting from the sale was incurred by the individual debtors, but was not incurred by the estate. Therefore, the taxes were not collectible nor dischargeable in the Chapter 12 plan. The dissenters were more concerned with the purposes of the chapter to provide relief to farmer debtors than they were with the technical interpretation of the phrase incurred by the estate. In essence, the dissent was willing to treat individual farmer and the bankruptcy estate as merged for purposes of interpreting these provisions. In my judgment, the dissent's interpretation is probably more faithful to the likely congressional purpose, but the majority opinion is certainly more faithful to the language in the statutes. That's one that calls out then for a congressional response. Next, in general, a tax deficiency must be assessed against a taxpayer within 3 years after the return was filed. That period is extended to 6 years when a taxpayer omits from gross income an amount properly includable therein, which is in excess of 25% of the amount of gross income stated in the return. That's Section 6501. In United States v. Home Concrete and Supply, the taxpayers overstated the basis of property they had sold, which resulted in an understatement of their gross income by an amount in excess of 25%. Relying largely upon its prior decision in Colony v. Commissioner in 1958, which interpreted virtually identical statutory language, the Supreme Court held that the 6-year statute was not triggered, since overstating the basis of property is not the same thing as, in the language of the statute, filing a return that, quote, omits an amount, close quote, from the statement of gross income. According to Colony, the statute is focused on situations where specific items of income are simply left out, and it was not intended to reach a case where gross income was misstated because of mistakes in inflating the basis for property that was sold. In other words, overstating the basis is not the same thing as omitting an amount. Finally, we cover 2 cases involving workers' compensation. The Outer Continental Shelf Lands Act extends the federal workers' compensation scheme that's established in the Longshore and Harbor Workers' Compensation Act to injuries occurring as the result of operations conducted on the outer continental shelf for purpose of extracting natural resources from the shelf. Well, in Pacific Operators Offshore v. Valladolid, the Supreme Court held that the workers' comp scheme could apply to an employee whose injury occurred onshore, but who could establish a substantial nexus between his injury and his employer's extractive operations out on the outer continental shelf. The plaintiff in the action was a roustabout who worked 90% of the time, 98% of the time on the outer shelf, but who was injured during that 2% of the time he worked on shore performing routine maintenance tasks. Because the administrative law judge had applied a situs-based test, just where did it occur, the Supreme Court remanded for consideration in light of the proper legal standard. Was there a substantial nexus? Next, the Longshore and Harbor Workers' Comp Act caps benefits for most types of disability at twice the national average weekly wage for the fiscal year in which an injured employee is newly awarded compensation. The plaintiff was injured in 2002, and her employer voluntarily paid disability for 3 years and then stopped. The plaintiff filed a claim for benefits, and in 2007, an ALJ issued an order compelling further disability payments. The issue for the Supreme Court was whether the cap should be measured by the weekly wages as of 2002 or as of 2007. In Roberts v. Sealand Services, the court held by an 8-to-1 margin that, as a matter of statutory interpretation, an employee is newly awarded compensation when he or she first becomes disabled and thereby becomes statutorily entitled to benefits, no matter whether or when a compensation order actually issues. The statute itself was ambiguous on the question, but the court chose an interpretation that avoids gamesmanship in making claims and ensures equal treatment of similarly situated beneficiaries. And that's it for this installment of the Supreme Court Review October Term 2011. Have a great day in the law. We'll hope to see you again for the next installment.